Ladies and gentlemen, we're about to start. Folks, we're going to start, so if you would get your seat, please, we would really appreciate it. It's going to be a fantastic program, so if you would take your seats, we will get underway. We want to thank you for spending your morning with us. Now that we have our new season starting, I'm Sandy. I'm involved with the volunteer group, the Friends of the Library. How many of you have a library card from the Teaneck Library? That's great, so you love the library. Now, on your other hand, how many of, yes, there we go, you know the question. How many of you are friends of the library? Because that's a separate membership. You know, your tax dollars go toward the collection here and other kinds of programming and this wonderful series. But all the concerts and all the movies and all of the other special events that you've attended, that's not through your tax dollars, that's through your support of the Friends of the Library. And you can support us in lots of ways. You can come and work with us. You can drop a dime into our donation box. You can sign up and get our terrific newsletters and first seating at all the special events. So think about what it would be like if there were no concerts and no movies and no special events. It would be kind of sad. So I hope that you'll join us, the Friends of the Library. You'll be getting your Dunning letter very soon. So I want to thank you for coming this morning, and now it's my pleasure to introduce Edie, I'm sure you know, for this very special lecture today. Thanks for coming.
Hi, everybody. Thanks for coming. This program is presented by Network for Responsible Public Policy, otherwise known as NFRPP. And for those of you who haven't heard it before, I'll just give you a brief rundown. NFRPP is a nonprofit, nonpartisan organization whose purpose it is to provide evidence-based, authoritative information on key public policy issues. And we all know that in these days of so much information, disinformation, false information, we're kind of overwhelmed. And our mission is to combat the distortion, and we want to help mitigate the polarization and foster a knowledgeable voting community, and encourage civic engagement so that our democracy can continue. Sometimes we really feel that it's at stake. Our speakers, who are authorities in their field, do this for us. We also have programs in other New Jersey locations, including Fairleigh Dickinson and Hackensack, and those are evening programs. If you would like to receive our online newsletter, we have information about upcoming events. We have recommendations of vetted, authoritative reading material, and there are sign-up sheets for getting on our mailing list. It's an email mailing list. There's one over here, and there's one in the back. There are also some flyers for our next program at Fairleigh Dickinson, which is coming up very soon. So thank you and enjoy the program.
Good morning, and welcome to today's lecture on the role of the Supreme Court in U.S. government. Our speaker is an assistant professor of political science at Fairleigh Dickinson University, where he teaches a wide variety of courses, including international relations and American government. Please welcome back Dr. Kyle Kattelman.
Cell phones, turn them off, just silence them.
Hello, everyone. Good morning. How are we doing? If I am too quiet, yell for me to speak up. I can get very loud if you'd like. Hopefully I don't blow out this microphone here, though. So I'm here to talk to you about the Supreme Court. Actually, let me get this up here. And this is a lecture that I actually give a lot to my American government classes. This is about halfway through the semester I get into this. This is a little bit of an in-depth civics course, civics lecture basically. We're taught certain things about the Supreme Court. We're taught in grade school that the Supreme Court is the branch of government that decides what's constitutional. And they indeed do that, however, it's a bit more than that. So the idea behind this is that when students go through grade school and high school, they're explained things on a very basic level. The legislative branch is the one that passes the law. The executive branch is the one that executes the law, and the Supreme Court is the one that kind of checks off, that makes sure that these laws are actually constitutional. In reality, it's never been like that. And so what I'm going to show you is where the Supreme Court actually fits into American politics. And I say American politics because what we're going to see is that the Supreme Court can be a political branch. But in today's polarized climate, I think we kind of tend to run away with that. That the Supreme Court gets very, very political. But what I want to convey to you is that it's always been political. And so I'm going to give you a big picture as to how it got to where it's at, where it fits into the relationship of American government, so that when you hear and see decisions brought down by the Supreme Court today, you can fit them into the broader picture, right? One of the things about polarization in American government today is that we pay very, very, very close attention. Which is actually a good thing, that we're paying very, very close attention. It's very important that we pay attention, but it's also important to figure out where these things fit, so that you can find out that if the Supreme Court does something, or if anything happens in American government, is it really unprecedented? Has it never been done before? Or is it a continuation of something that's been going on for a long time? So a little bit of a background about me. I'm a political scientist, so I apply the scientific method to the study of politics. So I have a Ph.D. in political science. I don't have a law degree. So I don't read every single Supreme Court brief. I'm not a legal scholar, so I don't know the law, the lingo of the law. So I'm talking about where the Supreme Court fits into American politics. So I can try to answer to the best of my ability after this some important questions about certain cases, but I might not know the answers to those. But I can kind of tell you where they would fit into the grand scheme of things. So it's going to be a bit of a history, a bit of a theory lesson. So let's dive in. Supreme Court, for the most part, I would dare to say, out of the three branches of government, for the most part, I would say it's the branch that's the most respected generally. Maybe you might disagree with me, that's fine, but I'm painting in broad brushstrokes. Generally, American public opinion, we tend to look at the Supreme Court in a revered light. We tend to think of Supreme Court justices as existing above politics, despite what we've seen in the recent couple of years, a very up-close look that these people are actually people. But before all of that, before things... Robots? They're not robots. Before all of that, we tend to think of them in revered terms. Have you ever toured the Supreme Court in the U.S. Capitol? Have you toured Congress? Toured the White House? When you take those three separate tours, they're actually pretty different, especially this contrast between the U.S. Congress and the Supreme Court. When you take a tour of the U.S. Congress, you'll see kids on field trips. They'll be walking through the rotunda. It'll be a very, very loud thing because they want the U.S. Congress to represent the people. But if you were actually to go and take a tour of the Supreme Court building, there's no talking. They don't really care to have children there. It's something much, much deeper than, just taking, you don't want to take kids on a field trip to the Supreme Court building. When you go into the Supreme Court chambers, you cannot take pictures. Pictures are expressly forbidden. And when Supreme Court justices hear oral arguments, there are no cameras allowed. Now, they released audio recordings of everything, but you're not supposed to see what's going on in there. And there's a very, very specific reason behind that. And that reason is the Supreme Court has no real power. And so where their power comes from is our reverence for the institution. So what I'm going to talk about today is that while the legislative branch has the ability to control the flow of money, and while the legislative branch has the ability to control the U.S. military, these are physical things that can coerce people to do stuff that they might not want to do. The Supreme Court has none of those things. And so they rely on this reverence. And so we're going to see essentially how the Supreme Court carved out a space for itself in American government, despite the fact that it wasn't given any powers. So we're going to talk about the genesis of the court system. The court system was established with the Judiciary Act of 1789. It was signed by President Washington. This established the lower court systems, and it's important to understand that this wasn't written into the Constitution. This was written by Congress. It's also important to understand that the Constitution, as revered as this document is, and as much as we like to level the insult that so-and-so is behaving unconstitutionally, I guess that's the biggest political insult that you can give someone. You're not listening to the Constitution. It's important to understand that the Constitution is not this perfect, chiseled in stone document. It is the longest lasting written Constitution in world history, so it is very important and it carries a lot of weight. But it was not written by people who were perfect. It was cobbled together by people who wanted to get 13 independent countries to form a new nation. And so as a result of that, it had to give every single state something that it wanted. And when you try to please everyone, a lot of times you please no one. And so the Constitution is a compromise document. We're going to talk about how, or I'm going to talk about it, how this factors in. It's a compromise document. So the founding fathers, when they were writing this document, they could agree on the methods of selecting representatives. They can agree loosely on the relationship between the states. They can agree loosely on the issues of electing legislators. But there was a lot of loose talk on a lot of key issues. And this is because they didn't want to come down hard and write an actual sentence that might alienate some states. So to this end, they left a lot of language vague. A lot of language that was vague concerned the relationship between the states, because when this was being written, they used the word state with a capital S. In political science, a state is an independent country. It's a sovereign entity with a centralized government, and it can essentially rule over its people however it sees fit. The United States of America thought of themselves like that. You can substitute country for state. The United Countries of America. They were very reluctant to sign over power to this new nation. And so the Constitution was very vague on what the relationship was going to be between these independent countries and this new national government that they were all supposed to be under. Additionally, they were very vague on the issue of slavery. That was a gigantic compromise. Slavery was necessary to be included in the Constitution, otherwise the southern states weren't going to sign on to it. So slavery was baked into the United States Constitution. There were a lot of things written in the Constitution that allowed for slavery to remain. And this is a big sticking point for the southern states. So it was indeed an imperfect document. And a lot of the language, and as the evidence shows, a lot of the language is actually vague. So for example, the role of Congress is to regulate commerce among foreign nations and among the several states. The necessary and proper clause for carrying out government's power. What does that actually mean? The necessary and proper clause is in Article 1 of the Constitution. But when we're talking about the Supreme Court and the judicial branch, it says Article 3, the judicial power of the United States is vested in a Supreme Court. So what is judicial power of the United States? Well, when the Founding Fathers wrote it, they didn't know either, right? So we have the articles, and the first three articles of the U.S. Constitution. Article 1 covers the legislative branch. They made it Article 1 for a purpose, and that's because they figured that the most important branch of government was going to be Congress. The most powerful branch of government was going to be Congress. It was also the longest and most detailed. They wanted to make sure they got this right because they thought that American government was going to center on the things that Congress did. Article 2 is the executive branch. It was shorter, less specific, but gradually over time, the executive branch has become pretty much even, if not a little bit more powerful than Congress. That's not what the Founding Fathers intended. And then you have Article 3, the judicial branch. It's the shortest of the three, and it's the shortest of the three for a reason. They didn't know exactly what it was going to be, but they knew they had to include it somewhere, and so they put it in there. And once again, the purpose of it was to get this thing signed. So the less you say, the better. So it was up to the Supreme Court to insert itself into American government. And because the Supreme Court has no real powers, no power to control an army, no power to take away funding from something, there are some consequences of Supreme Court decisions. What if the Supreme Court hands down a decision to a state? Nebraska, what you are doing is unconstitutional. We command you to stop. What if the court hands down a decision like that? Alabama, what you are doing is unconstitutional. We demand you to stop. When they do something like this, does a state have to listen? When they do something like this, does a person have to listen? And the short answer is no, they don't. Does that mean that states can do whatever they want? Does that mean that people can do whatever they want? No, it doesn't. But in the simple logic here, the court doesn't have any real power. They can just tell you to do something. It's kind of up to you if you want to listen to it or not. There is no recourse, no legal recourse that the court has in the Constitution to make a state listen to something that it rules. The Constitution, like I said, is vague. And so as time moves on and these vague issues are brought before the court does have some discretion on how it wants to issue its ruling. You can kind of think of the Supreme Court as passing laws using legal tools. I'm very glad that there are no Supreme Court justices in this room because they would vastly disagree with what I'm saying. But in reality, we can think of it like this way, that the Supreme Court is crafting legislation, but they're using legal tools to do so. The legislative branch actually writes the laws, but if they're vague, if they're conflicted, if the Constitution doesn't have a remedy, it's up for the court to determine how that law actually is meant to be read. And so they're writing laws, but they're using legal tools to do so. Does this mean that they can write a law however they want to write it? Theoretically, yes, but in practice, no. They can't write a law however they want to write it. And this is because, once again, they have no real power. So they have to be very, very careful on how they structure their decisions. They actually have to be careful on whether they even take a case at all. The Supreme Court turns down many more cases than it actually decides to hear. And before I go a little bit further, I will say that a lot of times the Supreme Court justices do vote 9-0, the liberals and the conservatives on one side of a legal issue. But the things that we're really interested in are the 5-4 decisions, right? The really, really political, where politics are unavoidable, these hazy legal things. So this is what I'm talking about. You know, the focus of this lecture are going to be on things like that. But a lot of times I will preface it by saying they do agree on a lot of things. I'm trying to say that it's a political branch, but in many cases the law is pretty clear 9-0. But that's not interesting for today. So the Supreme Court has no real power, which means if they pass a law, no one has to listen to it. But what good is it to be a branch to pass things that no one listens to, right? You want to be respected. So you have to be very, very careful on how you pass these things. And more specifically, you have to balance two things, two cornerstones of American government, two cornerstones. The first is popular sovereignty. That's at the core of every democracy. Popular sovereignty means that if the majority of the population wants it to happen, then for the most part, we should do everything possible to allow it to happen, right? If the majority of the population wants to set a speed limit at 60 miles an hour, then maybe we should give the majority population something like that. But sometimes the majority wants something that takes away the rights of a minority group. Banning certain people from eating at certain restaurants. A majority says a minority can't do that. Should we allow that to happen? Well, maybe on things like that, the majority can be wrong. So we shouldn't let the majority do anything that they want. We shouldn't allow any law or anything that's voted on by the majority to be allowed to be the rule. But it's still, when possible, we should allow the majority of people to get their way, because that is what makes a democracy. But there's a second part of it, and that second part is the rule of law. So we should allow the majority to dictate policy to us as long as it's within the bounds of law, right? We can't have a majority, for example, say we're going to make murder legal against children. It's legal to murder children. Obviously, that's against the law. And if the majority wants that, some big problems with the majority. But that's an extreme example. We know that that's something that's very, very illegal to do. So the Supreme Court has to balance these things. They have to balance what the people want versus is it legal? Is it constitutional what the people want? So they can't break the law for the people, but they also can't completely side with the law. If it's something very, very popular, but it might be a tad unconstitutional, they have to decide first whether they're going to hear the case. A lot of times they just don't. They just don't touch something like that. And if they do, they have to issue the ruling in such a way that it will uphold the law but please the people. A lot of times those two things overlap very, very nicely. What the majority wants is also very legal. Sometimes it's not. And that's the interesting part. That's when people start paying attention. That's when we get fired up about things. So that's what we're going to talk about today. So the goal is to make decisions within the boundaries of the Constitution, but also consider public opinion. Keep the people happy, because that's the only power they have, the reverence of the people. They don't have that, they have nothing. So what I want you to find out from this is that the court is indeed a political branch. There are things that there isn't a clear-cut rule to. A lot of times they issue 9-0 decisions, and that's because the law is very clear. But on those 5-4 decisions, where things are very, very hazy, that's where politics get involved. That's why we have big fights over who's nominated to the Supreme Court. That's why some of you are worried about Ruth Bader Ginsburg and what's going to happen to her if she passes while Donald Trump's the president. If they're truly objective, then these wouldn't be concerns. But we all know that they are. We all know that at the heart of it, they're people just like us. They have opinions just like us, but they are bound by the law. But like I said, the law is hazy. So there are certain cases where the opinions can creep in. And furthermore, because when the Supreme Court issues a decision, you don't have to listen to it, a lot of times the debates, especially contentious political debates, don't end with a Supreme Court decision. They go on. They go to another branch. They go to a people. They go to war. So the decisions are not binding, and that the decisions that the Supreme Court makes, some of them, are part of a political cycle. So we're taught as kids, we're taught in high school, we're taught in civics classes, that when a debate reaches the Supreme Court, that's the end of it, and then everything's settled. I'm going to show you some examples some obvious examples where that's clearly not the case. And so on those non-9-0 decisions, the Supreme Court is not the end of it. So I'm going to take you through a couple of phases. We're going to start with the first phase, when the Supreme Court actually started its business in 1789. And we're going to progress up to the Civil War, which was the biggest turning point in American government regarding the structure, the nature, and the power of the national government. Then we're going to go up to around 1937 when FDR came in, the first modern president, and the shift that happened then. Beyond that, it gets a little hazy. I can speak about some cases, but I'll stop there and maybe I'll start fielding some questions and see where everything fits in. So here we go. Establishing the right to decide. So this is in 1789 when the U.S. Constitution took effect. It was ratified and sealed in 1787, but it didn't start until 1789. So during this time, from 1789 to 1861, which is the beginning of the Civil War, this is a big phase in U.S. government history and U.S. history. It's a big phase in the Supreme Court. During this time, the Supreme Court had some challenges. During this time, the U.S. government had some challenges. Constitution was a compromise document. Things were very unclear. What's this relationship between the nation and these states? Are the states independent countries? How much can they get away with? What can they do? These are things that needed to be fleshed out within the Supreme Court and fleshed out within popular opinion. So the big thing was to preserve the Union. This is what this Supreme Court was trying to do under Chief Justice John Marshall. If there was no union with a capital U, meaning this union between these independent states. If there was no union, the Supreme Court had nothing to rule over. You couldn't issue an opinion on a country that is broken up into 13 separate pieces. It ceases to be. So the challenge of Chief Justice John Marshall was to read the Constitution in a way that would preserve the Union, to read the Constitution and to make decisions to side with one issue over the other in a way that the majority of people would respect and that the other branches of government would respect. So the goal was to preserve the Union. This nation-state relationship was very unclear. These states really wanted to flex their muscles and show that they still were independent states, that they still had some autonomy. No one likes giving up power, and that's what the states did when they signed the Constitution. So the court had to carve out a space for itself and to preserve the Union by issuing decisions and flex its muscle in a way that wouldn't alienate people, because remember, they had no real power. This meant that they had three interrelated problems. They had to establish judicial independence. Everyone looks to the legislature, everyone looks to the president. During this time, no one really knew what the Supreme Court was supposed to do. So they had to issue decisions and behave in such a way that they are looked upon as a third branch of equal status with the other two. And they had to do this through what's called judicial review. That's one of the legal terms that I know. It's a very important one, which I'll get to what that is. And then establish judicial sovereignty. And this is this idea that the Supreme Court can give itself the ability to decide whether something is unconstitutional or not. Now, none of these things are written in the Constitution. There is nothing in the Constitution that says that the Supreme Court is the interpreter of the Constitution. None of those things were in there. Judicial power is vested in the Supreme Court. It's up to Chief Justice John Marshall to determine exactly what that judicial power is. And he got his chance in 1803. This is probably the most famous Supreme Court case. I don't know if you've ever heard of this before, if someone's said this before on TV or in a book somewhere. We weren't around for this one, 1803. This is Marbury v. Madison. This was a hot topic, very contentious political issue that the Supreme Court found itself in the middle of. And like all contentious Supreme Court cases, politics are at the heart of it, right? So this is an example of how it can be a political branch. The political story, the context behind this, was that John Adams, the second president of the United States, was a one-term president. He lost to his political rival, Thomas Jefferson. I don't know how much you know about those two. Maybe you've seen John Adams on HBO, but they didn't like each other. They were vastly different people from vastly different parts of the country. Thomas Jefferson, for example, when he referred to my people and my homeland and my country specifically, he was referring to Virginia. He wasn't talking about the United States of America. As much as Thomas Jefferson loved Virginia, John Adams loved Massachusetts. Two very, very different people, very, very different views. And so they were huge political opponents. President John Adams could not stand the fact that he lost a second term. And so on his way out, as acting under the Federalist Party, John Adams was a Federalist, on his way out, he started filling out appointments for people who were Federalists to federal government positions. So he was doing what a lot of people do today. I don't like this guy who's coming in, so I'm going to leave him with a bunch of people who think like me. That he has to deal with those people, right? So he started stacking these judicial appointments for lower courts, not the Supreme Court, with these Federalists, so that when Thomas Jefferson came in as a Democratic Republican, he was going to have to deal with people who thought like John Adams. And then John Adams left the night before the inauguration. He couldn't stand to watch Thomas Jefferson walk into the White House, so he went back to Massachusetts. He was a sore loser. Founding father, sore loser. So he left office, and when he left office, he stacked the deck against Thomas Jefferson. This was called the midnight appointments. He was signing right up until the stroke of midnight whenever Thomas Jefferson was going to be legally the president of the United States, when he was going to be sworn in. So he was working right up until the very end. Okay, so signing a document, signing an appointment is one thing, but they have to be handed over by the Secretary of State in order for it to take effect. Secretary of State under Thomas Jefferson was James Madison. James Madison comes to his desk as the new Secretary of State. Here are all these appointments from his political rival, John Adams, that he has to deliver to these people in order for them to take their positions. If he delivers these positions, if he delivers these appointments, he's going to make life very difficult for himself and Thomas Jefferson. So what does he do? These are founding fathers. James Madison is a founding father, but he's also a human being. So he lets them sit on his desk. He's like, don't have enough time. I'm a busy man. I can't get these out. And lo and behold, because I can't get them out, it looks like some of these appointments aren't going to go through. William Marbury was one of those people. He was going to be appointed Justice of the Peace in Washington, D.C. He was appointed by John Adams, and James Madison never handed it over to him. So he was upset, rightfully so. What do you do in a situation like this? Clearly, the intention was for him to get this appointment, but it couldn't go through until James Madison handed it over. James Madison wasn't going to hand it over. So like children, where they have a dispute, you got to go somewhere, they work their way up to the Supreme Court. So now the Supreme Court is saddled with this dilemma. And this is a political issue. This isn't necessarily a legal issue right now. This is just politics. These are just two people from opposing political parties having a fight over a position of power where the law is a tad hazy. So what do you do with something like that? These things happen today. They happen all the time. You have something that's hazy, you have something that's political, and the court's going to issue a decision on this. And this is going to be a decision that is going to upset one side and really please the other, no matter how you cut it. And this is the dilemma that the Supreme Court found itself in. Chief Justice John Marshall himself was a Federalist. He was on the political side of John Adams, who is now no longer the President of the United States. So if the Supreme Court told James Madison, constitutionally, John Adams, we all know that he was legally doing everything, you're just being petty, hand it over. If the Supreme Court said that, it's very, very likely that James Madison would have said, make me. And then how powerful would the Supreme Court look? This would be their first momentous decision, and it just falls flat. And you know first impressions are everything, right? The first thing they do, the first big thing that they do, and doesn't work. So from then on out, they would have been established as just the third squeaky wheel of American government, so that they couldn't do something like that. However, if they upheld Madison, and if they were to say to William Marbury, James Madison doesn't have to hand it over, the Federalist-led Supreme Court would look like a tool and an accomplice to Thomas Jefferson, the Democratic Republican, their political rival. Either way, they would be seen as this subservient, squeaky third wheel of government. This is a political conundrum. How is it to be solved? What is the Supreme Court supposed to do? No matter what they do, they're going to be viewed as weak. And so this is essentially why Chief Justice John Marshall is viewed as one of the greatest Supreme Court justices of all time. Some of us would just shrug and say, Chief Justice John Marshall had to do something a little bit more. He had to get creative. So what they did was they went back to the Judiciary Act of 1789. The Judiciary Act of 1789 expanded what's called the original jurisdiction of the Supreme Court. It expands the realm of cases to which you go to the Supreme Court for a remedy. The U.S. Constitution established the original jurisdiction of the Supreme Court. The Judiciary Act of 1789 established the lower court system, but it also enlarged the jurisdiction, the original jurisdiction of the Supreme Court. So what they did was Chief Justice John Marshall looked at the Judiciary Act of 1789. This was a law passed by Congress, the first branch, read it, and said, this part right here where you expand the original jurisdiction that's been expanded to now allow someone like William Marbury to bring suit before us, that's unconstitutional. You can't do that. And so as a result, we can't hear William Marbury's case. So I'm not going to tell you to hand it over. I'm also not going to tell you to keep it. I'm going to tell you to go somewhere else. And you're going somewhere else because the United States Congress wrote something unconstitutional. Nowhere in the U.S. Constitution does it say that the Supreme Court can rule something like that. But they did. And because both sides were happy, except for William Marbury, but that's just one person. Because both sides were happy, if you want to make an omelet, you got to break some eggs. It established the right of judicial review. Judicial review is this idea that the Supreme Court has the right to determine whether an act of Congress is constitutional or not. Remember, it wasn't in the Constitution. They gave themselves this power, but they did it in such a sly, strategic way. They enlarged their power in such a sneaky way that no one was the wiser. Everyone was happy, and they didn't really realize what had happened until years later as they continued to exercise this power. That's why it's regarded as one of the most brilliant cases. So Marbury v. Madison established this idea that the Supreme Court can review an act of Congress. They can review an act of the branch of government. They can review an act of federal government and determine whether it's constitutional or not. But still, we have these states, these independent states, who think of themselves as independent, who are still smarting from the idea of signing over power to a centralized government. They still want to behave as states. Can the court tell them what to do? Well, you have to wait until they get their chance. And they got their chance in 1816 with Martin versus Hunters-Lessee. So Martin versus Hunters-Lessee starts out as a simple, well, not as simple, but it starts out as a very basic, petty, human dispute. I guess it's petty. I mean, if you had 30,000 acres of land, maybe it's a little bit more than petty to you. But the state of Virginia, during the American Revolution, started seizing land from people who were loyal to the British government, punishing them for being loyal to the very enemy that they're fighting. So the state of Virginia, and it was a state, during the American Revolution, it acted like a country, started seizing territory from people who were loyalists. The person he seized it to was Lord Fairfax. When the United States government, or when the United States signed the Treaty of Paris and then became later on the federal government, they put in a condition that if you were a loyalist, they engaged in a treaty. I mean, if you're a national government, the United States government, you conduct foreign relations with other states. And they conducted a treaty and an agreement with Britain that moving forward, we're going to return all the lands that we seized back to loyalists as a condition of peace, that we're going to treat the people who are loyal to you like American citizens, so we can paper this over and move on. So Lord Fairfax went to the state of Virginia and said, give me my land back. But you know how things go. 30,000 acres of land, you just sell it off to someone else. And what is that someone that's now on the land supposed to do? I'm not going to move. This is my house. This is my land. These are my deer. These are my turkey. I hunt them. I eat them. You can't do this anymore. You were a loyalist. So Lord Fairfax goes to the Supreme Court. And there's this issue. The state of Virginia thinks that it's reading the treaty correctly, that we don't have to give this land back. And furthermore, because the states were the ones that ratified the United States Constitution, it's up to the states to decide whether something is constitutional or not. Now, logically, this makes sense, right? It was put to the states to be ratified. You needed 9 of the 13 states, 9 of the 13 original colonies had to ratify the United States Constitution before it went into effect. So if it's ratified by the states, that kind of, you sort of kind of think that if we're going to give you power, we can decide whether we take it away or not. I would never hand something over to you that I could never get back. And the states thought this way as well. So Virginia thought of itself as we're the ones who are reading the treaty correctly, not the United States government. And it's centered on this fundamental question, a big fundamental question. This debate over land centered on this big constitutional question. Is the United States Constitution something that was created by the states or by the people? That's the big constitutional question. On the one hand, the states were the ones who ratified it, 9 of the 13. On the other hand, what does the first 3 words of the Constitution say? We the people. Now, I'm not a judicial scholar. I don't have a law degree. The actual decision is a little bit longer than that, but that's the gist of it. That when the states signed over their rights to a centralized government, they did this not in the name of states, but in the name of the people throughout all of the states. So the Constitution created a government not of independent countries, but of people that span across the borders of all of these states. It seems silly, it seems semantic, but there are a lot of huge philosophical implications to this idea. So we the people meant that New Jersey, Maryland, Virginia, the others, Delaware, Pennsylvania, Rhode Island, Massachusetts, I'm joking, I know them all. They're all people of this country. They're not citizens of Maryland, they're not citizens of Pennsylvania, they're citizens of this newly founded United States of America. And so this is the decision that established the right of the Supreme Court to issue decrees that the state of Virginia can behave unconstitutionally. They gave themselves this authority. This is also how they're able to, via Marbury v. Madison, to decide other branches of government whether they behave constitutionally or not. Again, hammering this point home, nowhere in the Constitution does it say they can do this. They gave themselves these powers. Moving forward, this issue of the relationship between the nations and the states, it's settled over things like territory, it's settled over things like acres of land, it's settled over things like a national bank. There are other monumental Supreme Court decisions that kind of hammer this point home that the states are not independent. But when it comes to something very, very, very contentious, when it comes to something that you really, really care about, rather than 30,000 acres of land or an appointment as a justice of the peace, that whole idea of this relationship between the nations and the states isn't fully resolved. There is an issue, however, where it can be tested, where the full metal of it can be tested. And that issue was slavery. So you can tell people to behave a certain way. You can say that states are subservient to the national government, and the states might go along with it if it's something they can give up on, if it's something they can compromise on, like a tariff, or 30,000 acres of land, or a position to the justice of peace. But like I said, in the United States Constitution, slavery was necessary to get all 13 states on board. Slavery was a necessary component in American government. Slavery, without the word being written, was baked into the United States Constitution. I like to tell my class that slavery is everywhere and nowhere in the US Constitution. They never say the word slavery, but they talk about it a lot. 2 big things they talk about, the 3/5 compromise. This allowed slaves to be counted as 3/5 of a person, but they don't use the word slave, but that's who they're talking about. 3/5 of a person for purposes of representation. This gives the southern states, who had fewer white men than the northern states, more representation in Congress, and this is what allows them to wield some power in American government. They would have never have signed on to the United States Constitution without something like that. That's a compromise over slavery. Another thing is the fugitive slave law that says if a slave escapes from the South and goes to the North, that slave must be returned to its master. It's a compromise over slavery without using the word slave. It's everywhere and it's nowhere. It was something that everyone cared about, and it was something that everyone had very, very, very strong thoughts about. And this was something that no Supreme Court decision can fix. This is something that no law can fix, as we saw in 1861, or as a book told you in 1861. We weren't around back then. So the Chief Justice that was in charge of the Supreme Court, that was in charge of keeping the Union together during this time, was Chief Justice Roger Taney. It's pronounced Taney, even though it's spelled Taney. He was the Chief Justice from 1836, Chief Justice John Marshall's death, until 1864. His role is boiled down to one Supreme Court case, but it was much broader than that. His role was the same as Chief Justice John Marshall's: maintain the integrity of the Union during a time where half the Union hated each other, right? How do you maintain that? Well, there was a tipping point on this issue because the idea that the North and the South hate each other was over one big contentious issue, a political issue. It was a political issue back then. You know, we obviously look at it as a human rights issue, that slavery is not a political issue anymore. But back then it was a political issue. The Dred Scott v. Sanford decision in 1857. This was the tipping point, and it showed how the Supreme Court actually never has power, right? It depends on reverence from the American people. So the story of Dred Scott v. Sanford, 1857. Dred Scott was a slave born in the Deep South. His master took him to Missouri, where he was sold to a military officer. Missouri was a slave state. During this time, his master took him to Illinois, then later to Wisconsin, although it was Wisconsin territory, so it's now present-day Minnesota. During this time, in these free states, Dred Scott met a wife, married, had a child, and then, crazily enough, became accustomed to this idea that maybe he shouldn't be a slave after going to a free state. So when his master took him back to the South, he sued for his freedom, saying that when you take me to a free state, because slavery is illegal there, I become a free person. And so therefore I have a right, as a free individual, to sue you in the court of law. And so this was upheld by a lower federal court in St. Louis, Missouri. That building's still standing today. It's this white courthouse. You can tour it. It's a museum now. It's not a functioning courthouse. And it was upheld. That federal court said that, yes, he can sue in a court of law. When you bring a slave to a free state, he becomes a freed person, he can sue. But it didn't stop there. It worked its way up to the Supreme Court. This is one person, one man, but the issues involved are much bigger than him, right? This is the crux of the Civil War. This whole thing goes back to slavery, right? There are a lot of things that the Civil War was about. You trace them far enough, they go back to slavery. It all goes back to this. So a decision on something like this, the fate of the country rests on it. People on both sides, North and South, are paying very close attention to this decision. And it's up to Chief Justice Roger Taney to do what the Chief Justice before him has done. Issue a ruling that makes as many people happy as possible, that doesn't promote an open revolt, and doesn't expose how weak the Supreme Court actually is. The goal is to uphold national sovereignty, popular sovereignty, give the people what they want, while also doing so within the boundaries of the law. But there's an art to it. Chief Justice John Marshall did it so deftly with Marbury v. Madison. What should Roger Taney do? Well, here's what he did. The question was, can a slave or someone who is a former slave sue in a court of law? Can they be treated like a citizen? That was the decision, right? Chief Justice Roger Taney wanted to preserve the Union. He himself came from Southern Maryland, a prominent, wealthy slave-holding family. He himself was pro-slavery, but he didn't want a civil war. He didn't want that. He wanted to issue a ruling in such a way that there wasn't a civil war, that he preserved the Union. He thought that by issuing a decision once and for all, if it came from the Supreme Court, it would put this issue to bed, and then we can go on to other things. We can just put this pesky slavery situation aside, and we can go on living our lives happily as ever. That's what he wanted to do with this decision. So he issued something sweeping. He wanted to tamp down this anti-slavery rhetoric at every single point, once and for all, forever and ever, and then the country can go on being the way that it was. So what he said was, black people were not American citizens and can never sue in the court of law. He went on to say that the founding fathers never in their wildest dreams, I'm not saying this verbatim, but it's equally as harsh language if you go back and read it. The founding fathers never intended for people of African descent to be held on the same status as white people. They're not subject to the same laws. They're not citizens. They were never intended to be citizens via the Declaration of Independence or the United States Constitution. He could have stopped there, right? And Dred Scott, just like William Marbury, only on a much deeper cut, goes home with the decision of the Supreme Court. But he wanted to end the debate once and for all. So he went on to say that the Missouri Compromise itself was unconstitutional. The Missouri Compromise says that Missouri is a slave state. Any other territories that are brought in that are states north of the southern boundary of Missouri have to be free. Chief Justice Roger Taney, doing just what Chief Justice John Marshall did, was said that a law of Congress is unconstitutional. He's exercising judicial review. But he's not talking about the Judiciary Act of 1789. He's talking about the Missouri Compromise, which was about something much more contentious. The Missouri Compromise said that free states have to be, or slave states cannot be north of the southern border of Missouri. He said that's illegal. Slavery and slaves are property, and you can't ban the holding of property in any territory. Slaves are property, just like a chair. I cannot bring a chair into Missouri, or I cannot bring a chair into a state that's north of the southern boundary of Missouri. That's ridiculous. The same logic applies to a slave. Done, right? We're done with this. Right? That's why we still have slavery today. He settled it once and for all. He thought that he did. He thought that he did. There was someone who was paying attention to it, and in addition to a lot of people were paying attention to this. Someone was paying attention to this. He was an American legislator. He served one term, but he went back to his law practice in Springfield, Missouri. He read the Dred Scott decision on his bed while he was touring the circuit court with his legal friends, and that was Abraham Lincoln. And when he saw that, when he read that decision, that made up his mind once and for all that he was going to get back into politics. It's something that he just could not stand for. Now, Abraham Lincoln didn't end slavery by himself. There were a lot of people who didn't like this situation. There were a lot of people who didn't like this decision. Most people in the North simply said, we're not going to listen to this. Half the country didn't listen to this decision and said it's much, much more important than a law. The South, of course, is like, you should listen to the court. Read your Constitution. When the Supreme Court says it is, that is what it is. We do that today, don't we? If it's something very, very political and the Supreme Court's on our side, we're like, that's the way that it is. That's exactly how it is. You should listen to it. But if it's something that we really, really care about and they didn't come down on our side, it's like, no, 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 no. You can take this with me now. I learned from this lecture that it's part of a political cycle. And a decision like this is indeed a part of a political cycle. 1857 was when this decision was issued. 4 years later, we went to war over the issue of slavery. So there was no law, there was no Supreme Court decision, there was no public opinion, really. It had to be settled with blood. The slavery issue was not this pesky thing that we can forget about. There's a reason why the Civil War was the costliest war in American history. It's because we cared deeply about something like that. It was a fundamental part of this country, for better and for a lot worse. A fundamental part. You can't avoid it. And that's the whole purpose behind the Civil War. The Civil War solved the issue of slavery, not a Supreme Court decision. During this time, the Supreme Court played basically no role in American government. Abraham Lincoln was the president. Roger Taney did not like Abraham Lincoln. Abraham Lincoln was anti-slavery. Roger Taney was pro-slavery. Every single thing that the Supreme Court did, Abraham Lincoln just pushed it aside. I'm fighting a war. I don't have to listen to you. Abraham Lincoln suspended the writ of habeas corpus, which is basically, if in this country, if you're arrested, you have to be told why you're being arrested, and you have to be brought before a judge within a reasonable amount of time, so that you're not languishing in prison for some ridiculous thing that you're never even told about, right? Like Guantanamo. Abraham Lincoln did this in the state of Maryland during the Civil War. He suspended the writ of habeas corpus on this little corridor between Baltimore and Washington, D.C., because a lot of pro-slavery people were disrupting telegraph lines and all sorts of supplies that were trying to get to the Union, all sorts of supplies trying to get to Washington, D.C. So he said that if you look like a rebel, you're just going to be arrested. We don't have to tell you why you're being arrested. You're arrested, and we're going to throw you in prison. During this time, during this time in American government, chief justices also traveled the circuit and they heard court cases. And so when he demanded people who were arrested be brought before the bench, he basically issued an arrest warrant for the president. How do you arrest the president? How does the Supreme Court command people who are controlled by the executive branch to arrest their boss? You don't. So Lincoln, rightly so, just forgot about it, didn't listen to it. This emasculated the Supreme Court. And it shows you that when they get the decisions wrong, it means bad news for the Supreme Court. So they really have to be careful about this, because this is not what Chief Justice Roger Taney wanted. He wanted the Union to remain together and slavery to remain here, and for the whites of the country to get along. It didn't work out like that. He didn't do his decision correctly. So the Civil War settled the issue. Slavery was illegal. Slavery was unconstitutional. The Emancipation Proclamation was an executive order, but it was signed into a constitutional amendment, and so therefore that settles that question. It had to take a war to do it. So after the Civil War, this relationship between the nation and the states was vastly altered. Now the states go from big capital S states to little s states, the states that we think of today, New Jersey, Maryland, the way that we think of it. We can just drive around them, drive between them. We don't have to give passports. The money's the same. The American dollar came out of the Civil War. Before that, each state issued their own currency. So the relationship between the nation and the states was vastly altered. It turned the country into what we know it as today. But obviously, 1865, the United States government was much different still. But that's the fundamental changing point in American history. And it was over this issue of slavery. So now that the slavery issue was settled, and now that the relationship between the nations and the states was settled, new questions emerged. We have a vibrant now industrial industry. We went through our industrial revolution after the Civil War. This idea of capitalism, people accumulating as much money as possible, money being concentrated in the hands of individuals at the expense of the many. These are the things that the country now faced. And so this is now where the Supreme Court went into. The question is no longer slavery. The question is no longer maintaining the Union. The Civil War settled this idea that a state can't secede, which, by the way, when the southern states seceded from the United States of America, was there anything in the Constitution that said that they couldn't do that? No, there was nothing there. It didn't say it was right, didn't say it was wrong. They just didn't have anything for it. So the southern state had a leg to stand on when they said that we can secede. Now we know you can't do that. A war had to be fought to tell us that. That's why Texas is still with us. Should the government control capitalism, and how? That's the new issue. And the idea is, do you side with the businesses, the people making the money, or do you side with the workers, the individuals who are slaving under these conditions, a new form of slavery? And the court tended to side with businesses. The Supreme Court justices were wealthy white men. They came from conservative families, and so they leaned conservative on things like this. They were naturally pro-business. A couple of instances of this, the slaughterhouse cases in 1873. In this instance, butchers argued, the slaughterhouse cases came out of New Orleans. During this time, there were butchers all over the city of New Orleans, and when they were done slaughtering an animal, they just take the guts and throw it into the street. Very hygienic. So the guts, it was called offal, O-F-F-A-L, offal. Offal, tomato, offal. All right, you got me. I'm showing my age. Offal. I learned something today. Now I'm going to go back to my class and say offal. Offal polluted the water, gave people cholera, made a lot of people sick. So the city of New Orleans said that we're going to consolidate, and we're going to take all the butchers and we're going to localize them under a private corporation, and they're going to be put downriver, so that when the offal now goes into the water, it's down from the people, all in the purposes of hygiene. These individual butchers formed a union and took it to the Supreme Court saying that their 14th Amendment rights are being infringed upon, that no state shall unnecessarily pass a law without due process. The 14th Amendment was written for freed slaves. It was to make them American citizens. But these are white butchers arguing that their freedoms are being deprived. The Supreme Court threaded the needle by saying, well, I know there's no state shall, and even though the 14th Amendment declared this idea of citizenship, but there's the difference between being a citizen of a state and being a citizen of the federal government. It's a very, very narrow reading of the 14th Amendment. It's not what the members of Congress had in mind when they wrote it. But that ruling stuck. And it wasn't just applying to businesses. Now that we have this idea that you can be a state citizen and a federal citizen, it's kind of going back a little bit. This allows states to discriminate against minorities, because you can be a lower citizen in a state, but you're still an equal citizen in the federal government. But as long as you're within Louisiana, as long as you're within Georgia, you're a citizen of that state and you're a lower citizen of that state. So it's the federal government's problem. States' rights, exactly. Another Supreme Court case was Lochner versus New York in 1905. This is a law, a New York law, that limited the amount of hours that bakers could work. Working in a bakery, I mean, I think it's still pretty strenuous now. I've never done it before. But working in a bakery back then, lots of heavy lifting, working around dust, flour, all these sorts of things, very hazardous to your health. So in the interest of public safety, the state of New York passed a law that limited the amount of hours that bakers could work. The Supreme Court struck this down as well, and it said that the right to a private contract, which is what you agree to whenever you sign over to an employer, I'm going to work for you for X amount of dollars, I'm going to work for you X amount of hours, it's a sacred right. So an employer can work his people as long as he wants to work them. This is, once again, the Supreme Court siding with businesses. And it basically said, overall, the Supreme Court was basically issuing this broader message. Anything economically concerned, you come to us. And that's how the American public kind of went along with. That's how the businesses went along with, because it benefited them very, very greatly. Worked like that up until the Great Depression. The Great Depression exposed the flaws in pure capitalism. And so Franklin Delano Roosevelt came into office and started issuing policies that were in line with his New Deal. And these were policies that cast these wide social safety nets. They expanded the role of government. It improved, or they sought to improve, the conditions of workers' rights. These were things that naturally went against what the Supreme Court stood for. The federal government during this time was starting to regulate the prices on goods. That was against the spirit of capitalism, and it's something the Supreme Court did not like. And so they fought him on every turn. They declared all these things unconstitutional. But their capital had run out. Their capital, speaking metaphorically, as in the support of the people. The Great Depression was so bad that people just wanted the government to do something. And here we have a president who is doing something. A lot of these things didn't work. World War II was the thing that got us mostly out of the Depression. But he was doing something, and the people were generally on board with that. The Supreme Court was keeping things the way that they were. And Franklin Roosevelt was elected again, and again, and again. And Franklin Roosevelt thought to himself, well, I have the support of the people. I've served more terms than George Washington himself. I don't have to listen to the Supreme Court. As a matter of fact, I'm going to go a little bit further. These people on the Supreme Court are old, fudgy, they need to go, right? They're stuffy old people, can't do it. They come from a different era. We're going to repopulate the Supreme Court with newer, younger, fresher minds, i.e. people who listen to me, who share my views. The public did support it for a decent amount. Not enough to actually get it pushed through. We still have 9 justices. But this spooked the Supreme Court. Now here's a branch of government that has the rule of the people. And now he's flexing on us, and it's starting to sting. So they quietly backed away. I got behind on the slides there. Re-election 1936, implied public approval, the court packing plan. So they decided to back away, but they did so very, very quietly, in a way that hopefully no one would notice, but eventually someone did notice. I noticed, right? I know about it. U.S. versus Caroline Products Company. This is an inconsequential law on the amount of milk fat in milk for interstate commerce. Doesn't really have much to do with the New Deal. They issued their decision, but they also put a footnote. And in the footnote, what they said is that from here on out, the Supreme Court is going to defer to Congress on issues of economic policy. So this is essentially handing a victory over to Roosevelt. We're surrendering the mantle of economic policy. From the Civil War up until now, we were the ones who controlled what was constitutional or not on economic grounds, and we basically let the businesses do whatever they want. Now, we're ceding to Congress. If Congress wants to write a law that we disagree with, that's going to be their thing. We can't win this battle. So they ceded the battle. They had to reinvent themselves. They had to make themselves more relevant. And so they moved on to civil rights in the 1940s and the 1950s. So this is going to be the last case that I discuss. Economic issues have been settled from the Supreme Court standpoint. This is something they can't win on. You have it. Let's go on to something else. Let's go on to something where we can still exert influence. Because every branch of government wants to increase power and remain relevant. So they go to civil rights ruling. The big ruling where they had their chance was Brown versus the Board of Education. We tend to look at this as this landmark Supreme Court decision, and indeed it was. But how consequential and how momentous was it in terms of the Supreme Court flexing its muscle? Well, once again, to show you that when the Supreme Court does something, it doesn't settle it, Brown versus Board of Education concerned school segregation in Topeka, Kansas. The Supreme Court originally in 1896 said that you can segregate as long as everything's equal, right? That should end it. Of course we know that it doesn't, because Brown versus Board of Education wouldn't have been around, they wouldn't have issued a ruling if the Supreme Court was the final ender of political debates. They overturned their own decisions. Plessy versus Ferguson established this idea of separate but equal. The southern states took this to heart and they segregated. Kansas is a Midwestern state. Segregation in Kansas was optional. It's up to a school if it wants to do it. In the South, it was mandated. And then there are states in the North that where you could never do it. But Kansas, it was up to the individual schools. The Topeka School District segregated, went to the Supreme Court, and the Supreme Court, this wasn't a political issue in the sense it was 5-4, it was 9-0, that segregation was unconstitutional. But once again, because segregation during this time was so deeply held onto by the southern states, they didn't want to issue a ruling in such a way that the South would openly not listen to it. So they said, with all deliberate speed, desegregate. They did this on purpose. They didn't want to give a deadline because they knew if they gave a deadline, the South wouldn't listen. So they say it's unconstitutional, but take your time and figure things out. The South said, oh, we'll take our time. And indeed they did. They decided not to segregate at all. This displayed the weakness of the court. They cannot order the southern states to desegregate. Who can order the southern states to desegregate? Well, in this instance, a state was never going to do it. It takes the federal government, and it takes two branches of the federal government. Little Rock, Arkansas, desegregate the school. The high school didn't want to desegregate. Who saved the day? The Supreme Court? No. Eisenhower, sending in federal troops. The executive branch controls the military, and that's how you make someone do something. You send in the military. You federalize the National Guard. You make them no longer the National Guard of the state of Arkansas. With the stroke of the pen, now you belong to Dwight Eisenhower. That's how you desegregate. Guns. That's how you make it work. That's how you had to make it work in the South. Going a little bit further, however, you can actually test this with empirics. So this is where political science comes into play. How momentous was the Brown v. Board of Education decision? Well, you can look at the percentage of black school children attending mixed schools in the South. And what you find was Brown versus Board of Education came in 1955. Those numbers didn't change at all. And they didn't even really change when Dwight Eisenhower made the Little Rock school change. That's just one school. It takes also another branch of government, the United States Congress, with the Civil Rights Act of 1964. Congress uses its money. And Congress says that if states do not desegregate, then you don't get federal funding. We're taking away your allowance. So segregation is something that, desegregation was something that happened, and it did help that you had a Supreme Court case that pushed it along. Martin Luther King Jr. said that he wouldn't have been as motivated to get involved in the civil rights movement were it not for this Supreme Court decision. But it itself has no teeth. A lot of times you need the cooperation of the other two branches of the government. So it took 9 years, but then it happened. And so this kind of goes to show you that if you want to advance things as a court, if you want to remain relevant, you do it incrementally. Marbury v. Madison, you do it without people really noticing. When you try to get out ahead of yourself, and you try to get into a political hot button issue where people are foaming at the mouth on both sides, and you think that a law or an opinion is going to change people's thoughts on the matter, you're really exposing yourself. You're really exposing yourself for what you are, a branch with no real power. So the key to all of this is to be a branch that makes policy, but to do so in such a way that balances popular sovereignty with the rule of law. And if you understand it through this lens, you'll see that the Supreme Court is a political branch that helps make policy. It uses legal tools to write legislation. That's how it does it. But it is a political branch, right? Those 5 to 4 decisions are political, and they have a role in policy. but they use judicial tools, and they clothe themselves in robes. They're not naked partisans. That's why they behave in such a courtly manner. And they do believe in the rule of law, and they do go to law school, and they are very good legal scholars. But at the end of the day, for the purposes of understanding what they do in American government, you can think of themselves like a political branch. Their decisions are part of this political cycle. If it's a very contentious decision, that's not the end of it. We don't necessarily have to listen. Little Rock, Arkansas, the high school didn't listen, but you don't listen to at your own peril. Sometimes if you don't listen to the Supreme Court, you get a gun in your face. Sometimes, but it has to come from somewhere else. So policymaking is incremental. So we tend to look in the future, looking at Supreme Court decisions, we tend to look at it as like, this will fix it. Hopefully they come down on my side, and if they do, it will fix it. If they don't, then it's just a part of a political cycle. So as you move forward and as the Supreme Court makes decisions, keep in mind this theoretical setup. They're not going to do things that upset the majority of people. If you're in a minority political position, they might not rule in your favor because they're only going to be satisfying a small minority. If you have a president that doesn't want to listen to him, they might not rule in your favor. Or a lot of times what they do is they just refuse to hear it. Those really contentious issues, what they do is they just refuse to hear them. They say, this is too hot button, this is too political. At the end of the day, in the US Constitution, we have these branches of government with shared powers. They're separate but shared. They go back and forth. It's part of a political cycle. But at the end of the day, the really big issues, the things that we care about the most, are decided by us. Slavery was decided by us. It was decided in the Civil War. Segregation was decided by us at the end of the day. It takes national groundswell social movements on things that we really, really, really care about. So moving forward, as you watch the news, as you see what the Supreme Court does, as you see what the president does, as you see what Congress does or what people say, keep this in mind. This is how you should interpret these things. And that's the formal end of my lecture. Thank you.
Very interesting.
Thank you.
I will remember 9/10 of what you said. I really enjoyed it.
I can give it, if there's a place I can put the slides online, you can go and access those.
Very good.
Thank you. Oh, I'm welcome to have a Q&A.
Excellent.
Thank you.
You scared me to death.
I scared you. How did I scare you? Oh, yeah.
Explain to me the Electoral College and the passing on there, let's say with Al Gore, where we went to sleep, he was president, we woke up, he wasn't.
Right. In the context of this is a 5-4 decision. That was a political issue, the election of...
Yes,
yeah.
but again, we're being hit with...
Yeah. I don't know if we're taking it from a group or I can answer individually if you want to come up. So how did it work? Essentially, we just accepted the fact that that's how it is.
What could we have done?
What could we have done differently?
Yes, like to show disagreement. Set fire to the White House? I mean, what?
I mean, riot, I suppose. I mean, like, when Donald Trump was elected, huge protests, right? But they're not big enough to change American law, to change the relationship between the branches.
Where should we have gone? To Congress and sat in on Congress or threatened Congress somehow? Or
I don't know. I mean, like, with the American Civil War, what should you have done to end slavery, right?